Hello. I remember one of my younger colleagues recently discovered, there was a just conversation, that how come someone can be responsible and yet not responsible? We're talking about civil responsibility, of course. Uh, it's different in criminal area, but in civil cases, the point is that to become civilly responsible, first of all, there should be someone who would try to make you responsible. Well, in criminal, it's more or less the same. There is a government, the crown, who just goes against you. But here it should be a particular person, like a private person, if you wish, including companies. So here is the issue. One can be responsible in principle and still not in practice. So how does it work? Why is it so? However disappointing it might be to those of us who just believe in justice in general and not in practice, because practical reality is, as always, different. Uh, there are several moments that can affect the situation. First of all, as we mentioned, there should be somebody who can sue you, and that person might not be interested in suing you. The most usual situation is when you are at the same time a person who can sue and the person who can be sued for something, or at least who can just demand something and from whom you can demand something. Let's say you're the liquidator, the executor of the estate, and you are the heir of the same estate and maybe even the only one. So technically you might do something wrong as a liquidator. But as long as the wrong is against yourself as an heir, you did something wrong, but yet in practice you won't be responsible. Or against somebody who wouldn't go against you because of good relationship and something else, for example, or some just moral obligations. Or, for example, you were a mandatory of some person, uh, and then that person died, and technically you're responsible towards the estate. But let's say again you're the executor of the same estate, and if the heirs would go against you, forcing you to go against yourself as the mandatory, that might be it, but maybe they won't. Of course, there might be creditors, so the situation might be different. But the point is, as you can see, like if there is anybody who can sue you, or, for example, there was a neighboring land, who wanted to sue you for a right of passage, and then you bought his land or obtained it somehow, uh, and now there is still a possibility for a claim, but you own both pieces of land, so, well, in reality, there is no issue, and then you can deal with that, like do some paperwork or something. So that's one situation where there is a responsibility, but there are no practical consequences in civil law. We're not talking about criminal. Second, again, yes, you might do something technically wrong, maybe even unlawful, but it did not entail in any damage, like at least measurable damage, provable damage. And a civil responsibility requires the proof of damage. Like, for example, somebody did badmouth you. It was, in your eyes, very unpleasant. So you claim that it was defamation. But at least in Quebec, badmouthing, it's not enough. There should be proven damage. Cannot prove damage. Or if your action would cause you more damage than the initial actions of somebody else. And then again, in reality, even somebody isn't wrong, then the real responsibility doesn't come. On the contrary, there might be a situation, though there are exceptions and caveats to that, but technically there might be a situation when somebody did do you some damage, but without a fault. yes, there are no-fault regimes for certain situations, but not for all of them. So sometimes no intent, no like unlawful, illicit intent in somebody's actions. Somebody was duly diligent. Somebody acted as a reasonable, law-abiding person would act in the same situation with the same knowledge and so forth. And there might be, again, no responsibility, even though the damage was caused and even though there is a person who can sue. And finally, well, there are more situations, but those are the biggest. Finally, let's say there was some fault, there was some damage, and there is somebody to sue. But it's hard to prove that the damage was actually directly caused by that fault, because there might be somebody or something in between. For example, you might pretend that somebody's actions caused you economic loss because of the loss of reputation on the market, but in the meantime, there was like a huge downfall in the market altogether. So it would be hard to prove what part of your actual loss was caused by that action and what was caused by the fall of the market altogether. Something happened in the neighboring country, for example, or COVID happened. And then the issue would be, again, was it because you couldn't work due to some flooding for a couple of weeks, or because of the situation when like all the businesses around were out of business anyway, and so forth. Or sometimes, as it happens in some defamation cases, for example, somebody did badmouth you, but it probably affected like 1, 2, 3, 4, 5 people. And then when you started to publicly fight about that, you spread this information to like hundreds and thousands. And then the conclusion might be that actually it was you who caused all the damage, or at least like a significant part of it, not the person who originally badmouthed you. So, because of these four and some other like smaller things, in civil case and civil court, with respect to civil responsibility, there might be a situation when somebody is responsible in principle by law, but is not in practice, because the dots cannot be put over I's and T's cannot be crossed properly, or nobody would even care to do that. So here it is, about that civil responsibility and the cases where it doesn't come. Thank you, and have a nice day.